Hello, everyone. This is Tom Fox, and I'd like to welcome you to episode 162 of the FCPA Compliance and Ethics Report. Today, I visit with Kristine Robidoux, QC, a partner at the Gowlings Law Firm in Calgary. She is an white-collar defense practitioner. She specializes in anti-corruption programs, policies, and investigations all north of the border. She's going to visit with us today about some new whistleblower regulations instituted by the Ontario Securities Commission, which she believes will dramatically affect the ability of Canadian authorities to obtain information about potential corruption and bribery violations of the Canadian law. The episode comes in at just over 22 minutes, and as always, I hope you will send in any questions, comments, or other information that you have. I'm Fox, and I would like to welcome you to this episode of the FCPA Compliance and Ethics Report. Today it is my distinct pleasure to have my first QC from north of the border, Kristine Robidoux, if I pronounce that correctly, a partner at the law firm of Gowlings and a lot of other names in Calgary. Chris, if I got that close to right, welcome.
Well, thank you very much, and very well done on the pronunciation.
I have to say, in South Texas, we would pronounce that Robidoux, but that's a different issue for perhaps a different discussion. Nevertheless, Chris has a very interesting practice, and she specializes in white-collar defense, and you're a member of the firm's white-collar defense and investigation group. But the thing that led me to see if you could visit with us down here in the South of the border would be your work in the Canadian anti-corruption sphere, specifically the Corruption of Foreign Public Officials Act, other anti-corruption legislation, and some very interesting new legislation or regulations that the government has brought in regarding whistleblowers in Canada. So with that somewhat long-winded introduction, why don't you tell us a little bit about your practice, Chris?
Well, thank you, Tom, and thank you for this invitation to participate and engage with your guests. It's a very exciting time to be practicing in the white-collar or transnational crime space up here in Canada, because after so many years of dormancy, there's really an investigative and enforcement push that's occurring. Legislative change, enforcement agency change, policy change, that's catching, I think, a number of companies flat-footed up here. You know, we tend to see that whatever happens south of the border in terms of regulatory and enforcement change tends to trickle up north over time, and that is certainly the case now. So, in the anti-corruption world in particular, I've been practicing in this area. I had a solo compliance consulting firm back in 2004 through 2008, and I remember talking to boards of directors about the fact that Canada had the Corruption of Foreign Public Officials Act on the books, and the fact that it wasn't being enforced at the time, nonetheless, shouldn't cause companies to believe that the risk was not there. And very often, Tom, I would get looked at like I had three heads in the boardroom, because it was not seen yet to be a risk that boards needed to really pay attention to. But then we did see the FCPA and the enforcement activity that was going on, and in the United States, and Canadian companies did start to pay attention. And then we were counsel on Canada's two major prosecutions to date under that law, one in 2011 and then the Griffith Energy case in 2013. And then we really saw that companies wanted to take this seriously. And as we know, robust compliance is such a vital part of avoiding the costly and the damaging enforcement actions that can flow from corporate wrongdoing. So we've been talking about whistleblower programs with clients and the need to have them, and so it's timely for us to see that the Canadian regulators are coming around to this view, and they've introduced at the Ontario Securities Commission a proposed framework for an incentive-based whistleblower program that will be not unlike the Dodd-Frank Act in the United States. So when you look at, not to put words in the mouths of my clients, but it might be a little bit of that perfect storm, because we now finally have credible and robust enforcement of the foreign corruption legislation. We have legislation that has been passed and is just awaiting implementation in connection with the reporting by extractive sector companies of all payments made to governments, boards, quasi-governments, etc., which is called the Extractive Sector Transparency Measures Act here in Canada. And then the third, part of that triangle, that perfect storm, being the potential for this whistleblower program to be administered by the Ontario Securities Commission.
Chris,
so we're not short of work.
Yeah, if I could stop you there, and let me go back to your second point on the perfect storm, which was the extractive industries issues. One of the things I've been curious about is what has been the effect of the SNC-Lavalin matter with not only white-collar practitioners from yourself who would be very aware of it, but from the business community. Do they understand that maybe the world has changed now?
Well, I think absolutely that there's a recognition that the world has changed, Tom, and what of that has to do with the SNC-Lavalin case or not, I really can't say, and I can't speak to that case specifically. But certainly, when we don't have a history in this country of seeing fines in the tens of millions, let alone the hundreds of millions of dollars, as we're seeing coming out of the United States. So when NICO was fined $9.5 and Griffith Energy was fined $10.5 million for violating the Corruption of Foreign Public Officials Act, that got people's attention. The fact that SNC-Lavalin is going through that process now, I think, we'll have to wait and see what happens with all of that. But yes, there's been an awakening for sure.
And now let me turn to your point number 3 on the Ontario Securities Commission. Why do you feel that is, if not the appropriate body to do this type of regulation and to have this sort of oversight, and specifically a whistleblower program?
Well, the Toronto Stock Exchange has one of the largest concentrations of extractive sector companies, in particular mining companies, of any stock exchange anywhere in the world. And I can't remember right now the number, but it's several thousand. And so when you consider that you have this body of entities generally conducting business in high-risk jurisdictions, the OSC is, I think, very correctly looking to why it is that they don't have a larger number of serious cases that are currently being investigated. They make no jokes at all about the fact that they're looking at what the experience is of the SEC in the United States and the number of tips that are coming in and the success that the SEC is reportedly having in administering this program. And frankly, they've been keeping a very close eye on the program since it started in 2011. And with the acknowledgement that the OSC should have more complex cases than it currently has on the go, it has caused them to look at that program for a similar program here in Canada. And I think that getting back to the TSX as an exchange and the types of companies that are listed on that exchange, I think that it is their expectation that this will be as fruitful for the OSC as the Dodd-Frank measures have been for the SEC.
Chris, could you walk us through some of the mechanics since they've been worked out on how this is going to work? So perhaps contrasting with or comparing with what the SEC has in place, does a person have to self-report, for instance, to their organization? Are there additional awards that can be uplifted if they do self-report before going to the Ontario Securities Commission and those sorts of procedural issues?
Absolutely. Well, I think that as a general statement, I would say that this proposed incentive-based program is stark in its similarity to the Dodd-Frank provisions administered by the Office of the Whistleblower in the United States. Very, very similar. A couple of key differences or perhaps minor distinctions, Tom. I would say that firstly, to your question about whether or not there will be a requirement for a whistleblower to report internally first, at this stage, the OSC does not appear to be willing to require that they go internal before being eligible for the whistleblower program. And in fact, the OSC is expressly arguing that that type of prohibition might not be appropriate where an individual has concerns about the efficacy of the internal reporting procedures or fears retaliation within his or her organization. So that is a question that the OSC has asked for comment. And I should have said that from the outset, Tom, that the program was the proposed program was put out back in February of 2015. The OSC left the comment period open until May the 4th. And so comment period is now closed, but they're hosting now an additional round table on June the 9th to further explore some of these issues. So it's clear that they want to hear from practitioners and companies and academics. They want to hear about some of these issues, but that's one of them that they're still eager to hear comment on. Another point that they're specifically looking for comment is whether there should be a cap on the amount that a whistleblower may be entitled to. So unlike the Dodd-Frank Act, in Canada, the proposed OSC model provides for awards up to 15% of the sanctions that are imposed or the settlement amount that is agreed to a maximum of 1.5 million Canadian dollars, and only if the total monetary sanctions exceed 1 million Canadian dollars, excluding costs. So again, if one considers that, if there's to be a cap of 1.5 million dollars, is there a suggestion that that's not enough of an incentive for a bona fide whistleblower to bring concerns to the OSC? That's an open question. Importantly, also in connection with the award, the award would be based, Tom, not on the amount that is collected by the SEC in response to an allegation or an enforcement action, but rather the amount that is imposed. So in that way, a whistleblower won't have to wait, or his or her award won't be contingent on the OSC's ability to collect on that penalty.
Chris, one of the things that has been of significant development here in whistleblower issues over the past 6 months or so has been the protection of whistleblowers from retaliation, whether that be retaliation in terms of reduced workload or other retaliation inside of a job or actual termination. Is that something that the Commission is looking at, or are they asking for additional comment, or do you think, frankly, that the protections are in place, particularly for the way companies do business in Canada?
No, I mean, my personal view is that there aren't, sufficient protections in place to date. But the OSC, as part of this proposal, intends to enact 3 new statutory provisions under the Ontario Securities Act, which will protect whistleblowers from retaliation. And specifically, those amendments, again, there's 3 of them. The first is that it will make it a violation of securities law to retaliate. So that would then allow the OSC to prosecute the employer under the Act. Secondly, it would give these statutory amendments would give the whistleblower a civil right of action against an employer who violates those anti-retaliation provisions.
Mm-hmm.
And thirdly, they would render contractual provisions designed to silence a whistleblower unenforceable. So the pre-taliation aspect of it.
Right. What about if I'm an American here in Houston working for a Canadian company? Am I protected by this particular Whistleblower Act?
Yes. There's no there's no suggestion that either a whistleblower needs to be Canadian, or that by virtue of not being Canadian, that you would not be able to enjoy the same protections. If the company is subject to the Ontario Securities Act, then that would apply regardless of your nationality.
And would it apply if I made a complaint from, or rather a report from outside of Canada, say from the United States or indeed Europe, Africa, Asia?
Again, would not matter. It would be the OSC's jurisdiction over the company that would give you the ability to report and the protections afforded by the Act here in Canada.
Well, it certainly sounds like some of those protections that have been litigated here in the United States may be more well thought out under this Act.
Well, it'll be interesting, Tom. I mean, I do think that's a little bit the Canadian way, right? I mean, some would say that it's really not our culture in Canada to encourage whistleblowing. We do, and this is my personal view, my personal observation is that we tend to be a little more European in that way, and not avail of those types of whistleblower programs. But on the regulator side, I think that, again, it's very Canadian to not rush and to wait and watch. And I think that the OSC has been very wise to observe with interest the experience of the SEC and the Office of the Whistleblower, because there are aspects of that program that I'm sure the OSC wants to emulate. And there may be aspects of that program that the OSC perhaps believes they can do differently or better. And so it's, and these things tend to not come about overnight in Canada. And the fact that they put the proposal out and left it open for a rather lengthy comment period, still going back to industry to host this roundtable to further explore these issues, that's all a sign that I think they really want to make sure that they nail it.
Chris, you had mentioned a couple of times this period of comment, but I wanted to ask you about, I believe you said there was an upcoming conference or roundtable where these issues could be, if not further explored, further commentary or input from the public or companies or lawyers such as yourselves. Could you describe that process for us?
Well, that is, so again, the OSC had requested written submissions and comment up to, and in fact, including the week after May the 4th. You can go on the OSC's website at osc.gov.on.ca and see the written submissions and commentary that have been submitted. But in addition to that, they've announced that they will hold a roundtable to further explore these issues, and that will take place the morning of Tuesday, June the 9th, at the Commission's offices in Toronto. There will be a panel discussion reflecting viewpoints of investors, market participants, members of the Securities Litigation Bar, and other stakeholders. So if parties wish to participate as a panelist, then there's a mechanism on the OSC website to direct people to how to do that. The OSC will give us, that's really all the detail we have for now, Tom, but the OSC expects to give additional details, including the agenda and the list of panelists, by June 2nd.
Well, that certainly sounds like a very interesting opportunity for additional public comment that I hope folks will avail themselves of.
Well, I hope so, too, because, again, I do think that these programs can we don't want the OSC to be so blinded by the prospect of more and bigger and better cases that it goes about enacting a program that will be counterproductive, not efficient, doesn't sufficiently protect whistleblowers, et cetera. We really do want them to be pensive and as they go about this. And so I think that, again, it's appropriate that they keep going back to stakeholders the way they are.
Chris, I cannot think of a better description of the difference between U.S. law enforcement and Canadian law enforcement than your use of the word pensive. That, in my mind, absolutely encapsulates the difference between the U.S. and Canada. You guys are pensive, and we just go off half-cocked and run down the road, yelling and screaming. So that's a perfect word. Great. Chris, we're nearing the end of our time, but we're recording this, I think it's May 28th, and the news of the day here in the U.S. is one word pronounced several times, FIFA, FIFA, FIFA. And since Canada's going to be hosting the Women's World Cup soon, I was wondering if you've been asked for any commentary on that, and is it at least as big a news in the white-collar and anti-corruption space in Canada as it is down here?
It is absolutely big news here, Tom, for lots of reasons, but primarily the reason that you just identified, which is, Canada right now is so excited hosting the Women's World Cup. I'm going to the tournament opener on June the 6th. Can't wait. And Canada also rumored to be bidding for the 2026 World Cup. And so for the sport and the governing body of that sport to be mired in this drama today and over the course of the next number of months is sure to detract from some of it. We don't want to see that happen. Canada really wants to celebrate this Women's World Cup. We will celebrate it, but from the perspective, I think the sport and and FIFA, I do think it will cast somewhat of a pall.
Well, Chris, unfortunately, we're near the end of our time, but I was wondering if anyone wanted to follow up with you on some of the things that you visited with us about. Could they email you, and if so, how would they do it?
Very happy to have folks reach out to me directly, Tom. I'm with the Gowlings firm, and I can be found on the Gowlings website, but my email address is Kristine with a K, .Robidoux, Robidaux, @gowlings.com.
Well, Chris, thanks very much, and I'm very much looking forward to continuing the conversation.
Likewise. Thank you again for the invitation to participate.
All right. Cheers. This is Tom Fox again. As I have announced in several prior podcast episodes, I am now taking questions for a mailbag issue. If you have any questions, I hope you will send them in. You can do it as a comment to this podcast, or you can send me an email at tfox@tfoxlaw.com. Thank you very much.